10% of the population in the UK holds digital assets, cryptocurrencies and crypto tokens or NFTs. I think that we transacted about $280 billion worth of digital assets. I think we're 14th in terms of the globally transactionally, but third in terms of the value of what we're transacting. So the bill is looking to enshrine a third category of property right.
Crypto was being stolen. People were trying to recover it. First of all, can you recover it? The court weighs in and says, yes, it's property.
I could say, in England, Wales, we seem to be driving this and at the forefront of this, which I think is fantastic. Yeah. That's aside from any comments or thoughts about digital assets themselves, but I think the fact that we're leading the charge on this is really, really good.
You don't have to wait till this bill is passed to take action. The courts are still there. They haven't disbanded.
No. Good afternoon, Kieran.
Hello, Roman. How are you doing?
I'm very well, thank you. Very well. How are you?
Fine. Cold.
Yeah.
Today is the -1 day.
Taking the toll, doesn't it?
Yeah,
it was quite something heading out this morning at 6 a.m. to feel
bracey.
Yeah,
the
bracey.
Bracey,
yeah. It is bracey, but hopefully I've got something today to warm your cockles.
Oh, do you know, I'm excited about this one.
Good.
Well, I am. I mean, I say that somewhat facetiously, but no, I am. It is interesting.
It's a relatively big moment for us sort of digital asset lawyers.
Yeah.
Because we are talking today, folks, about the property and in parentheses digital assets, etc. bill. I love that, etc.
I love that. It
could
be
digital assets
just etc.
stuff. Just a bill about stuff, including digital assets. So,
exactly.
And what a bill it is! It's I wish all my bills were like this because it's a very short, small bill.
Indeed.
Isn't it? So it's got all of 2 sections.
Yep. Yeah.
And but I mean, we can delve into those sections a bit, but let's give some context about the property, digital assets, etc. bill. First of all, I mean, it is a bill, which means it's not yet an act of Parliament, isn't it?
Yeah, I was going to say, let's take the listeners through what that really means. It's effectively a consultation, between House of Lords, House of Commons, and wondering what this is all about, and whether they're going to approve it.
Kicking the tires on it, making sure it's all robust.
Yeah, and it's frighteningly small.
Yeah.
As a bill.
Yeah.
But it just shows you how they're looking at it very seriously, because even though it appears to not do a great deal in terms of its substance, in terms of the actual size of the bill, it will provide much needed clarification.
Yeah, so it's more like a chick's bill than a platypus bill.
Yeah,
isn't it? So
exactly
it's
right.
Small but to the point. There
Nice.
we go. I won't labour that metaphor anymore.
Chick's bill.
Chick's bill. There we go.
Yeah.
So now, look at the like this. What happened was the government asked the Law Commission a few years ago, around 2019, to review the law on digital assets. 10% of the population in the UK holds digital assets, cryptocurrencies and crypto tokens or NFTs.
Yeah.
So, I think that's probably not that surprising, actually.
No, I don't think it is. And I mean, you came across a stat earlier when we were talking that the UK is a huge centre for this.
Yeah, massive centre. I think that we transacted about $280 billion worth of digital assets. I think we're 14th in terms of the globally transactionally, but third in terms of the value of what we're transacting. So the UK is a really big player in the digital asset space.
Yeah. So not just with the average consumer buying Bitcoin, but also the actual flow of how all of this works and pieces together on a global scale comes through here, which is and starts from here, which is great.
It is great, and I think it's been a real conscious decision, and all praise to the courts, because the courts have really embraced this, haven't they?
Well, I was going to say how much has that been driven recently by the fact that here you have a jurisdiction where the courts have got to grips with this very well.
Yeah.
And very effectively. And actually, when you look at this bill, it pretty much says the courts have already done what we are trying to do, but we're just going to enshrine it in statute anyway. and over to the courts again to keep on navigating their way
Keep
through.
grappling with it. Yeah, because what the bill proposes to do, and it's just, well, at the time of filming this, it's just had its second reading in the House of Lords, and I'll talk through the various stages of how a bill becomes a law.
Yeah.
But what it proposes to do is to confirm and clarify that a digital asset is or constitutes property.
Yeah.
A third category of property.
Yeah.
Isn't it?
That's right.
Because there are two, so traditionally, historically, there have been two types of property, haven't there?
Yeah.
A thing in action.
And a thing in possession.
Yeah, so a thing in action is a right to claim against something.
Yeah.
And then a thing in possession is obviously something tangible.
Yeah.
Whereas for a while, digital assets didn't really fall into any of those categories.
No,
Or of those categories.
Yeah, and you can see why, I suppose, because is it currency? I mean, here you can hold £1 English, but you also have it, representing £1 English in digital form in your bank account when you log onto your phone, etc.
Fungible pound.
It's a fungible pound, yeah. And then you also have the other analogy, which is a share. A share in a company is kind of like having a Bitcoin in a way, because if you sell that share and there's value in that share, you get the money, you get the currency.
Yeah, I guess the key difference there is that the share is linked to, well, it is a share of a company which is tangible, produces an income, whereas Bitcoin is purely digital. It's not linked, unless it's a stable coin, it might be linked to, but something like Bitcoin is purely digital, it's not linked to anything, it's decentralized.
Exactly.
So this is what the bill is looking to enshrine, a third category of property law, and that, as you spoke about, you've got cases, 2019 case of AA and persons unknown, which confirmed, in which the courts said that, that digital assets, cryptocurrencies are property.
Yeah.
For purposes of the law in England and Wales. You've had the case of the lawyer, you've had tulip trading, all these cases, and the key behind this is, as these cases are hitting the courts, people need to, and if people are going to invest in digital assets, and if they're going to see the UK as a hub and England, Wales as a hub, digital hub essentially, for this, then they're going to want to feel safe that if their cryptocurrency gets stolen, or if there's an argument about copyright infringement over an NFT or anything like that they can bring a claim to recover that asset, or to deal with copyright arguments, or to dealing with smart contract, whatever it might be, and you can only do that if the asset in question is categorized. Yeah,
that's right. And because I think before AA and persons unknown, it was, the court needed to figure out whether this property could be pursued and recovered, or otherwise dealt with. Because if not, why are you here at court trying to recover it and get a result and enforce and whatever it may be? So, such to say, if your house was burned down or whatever it might be, you would want restitution of that. It's the same. Or fiat currency was lost. That is property. So therefore, you can attach a legal argument to it and recover it, which is why. So actually, all of this was borne out by the fact that crypto was being stolen. People were trying to recover it. First of all, can you recover it? The court weighs in and says, yes, it's property, therefore you are owed it back. Yes, recover it.
In theory, but they've got to have the practical steps to do so. And obviously that we talk about that in another podcast. But I think one of the big things which swayed the court and the Law Commission and the House of Lords as it's making its way passage through is that the rivalrousness of it. So effectively, it's, this glass is mine, you can't have it.
Absolutely,
No offense.
Yeah. But I mean, it is. You may own a gold bar, and no one else can own it, and that's the rivalry. Yeah, I don't think anyone had ever used
rivalrousness.
I don't think anyone had ever used that. That before, rivalrousness.
And there's a lot of new terms. I'd say, non-fungible.
Well, exactly. But this is it's all part of the same thing, which is this is all very new.
But good to say, in England and Wales, we seem to be driving this and at the forefront of this, which I think is fantastic.
Yeah.
And that's aside from any comments or thoughts about digital assets themselves, but I think the fact that we're leading the charge on this is really, really good. So obviously the passage of it, so the bill has to go through this process, doesn't it, being vetted, or the tire's being kicked on it through either it goes first through the House of Lords and then the House of Commons, or House of Commons first and House of Lords, who's sponsoring it and so on. So I think it's being sponsored by Lord Ponsonby, I think it is. I know I mispronounced that. But so it started live had its first reading in the House of Lords. So effectively, it's an introduction. There's no debate on it, but effectively it's read during a parliamentary session. And then it's effectively introduced, and then it's printed, and then it moves on to the second reading, which is what we've just had. So there, the Lords can debate the key principles around the bill, make any changes to wording and so on. And I mean, while as far as I'm aware, there weren't any proposed changes, I think it had a fairly good passage through the second reading. Prior to that, during the consultation phase, I'll read the bill because it won't take long. But so section 1, objects of personal property rights. A thing, including a thing that is digital or electronic in nature, is not prevented from being the object of personal property rights merely because it is neither a thing in possession nor a thing in action. That's really broad. So that could, apply to digital assets now.
It's very broad.
But we don't know in 100 years' time what they could attach it to.
And which is exactly what they've done there.
Yeah.
So, but basically, what it's saying is that if you don't have a classic example of a thing in possession or a thing in action, whatever you are looking to establish as property could be property.
Yeah, exactly. And that's it. And this is the point, that they changed the wording. So they had originally said a thing, including a thing that is digital or electronic in nature, is capable of being the object, whereas now it's saying is not prevented from being an object. So small change, but again, this is what
significant. I think. Yeah, exactly. And it's interesting because when you look at the background to all of this, they often then say, okay, well, it's now over to the courts to develop it.
Yeah.
But the irony is that the courts have been developing this from the start, and I think there is a sense here that government is going, oh, okay, we also need to look like we are forefront, at the forefront of all of this. So here's a bill, of which is all but one page long.
Yeah.
But it is useful because you'll have two avenues to pursue. If there is a problem or you want crypto recognised as property, you now have two avenues to pursue that, or attach that to.
Well, you've got you've got the sharded statute, and then you've got the courts willing to do that, and then at that point, then it goes to the committee stage. So that involves basically line by line examination of it. You then move on, and from there you've got a reporting stage. And then you get the third reading, and by the time you got to that, then it goes into the House of Commons, and then you have a similar process there. And then, assuming that's all fine, you then have royal assent, and then it becomes an Act of Parliament. Yeah. And frankly, I suspect it's going to have a fairly smooth passage through.
I think so.
Lords and Commons.
Yeah, I think so, and it's on the back of, we touched on it at the start, didn't we? The Law Commission report, which I remember. You and I submitted our 2 pence thoughts on that.
That's right. Yeah.
And they asked for industry opinion on whether there should be this third category of property rights, and I think there was an overwhelming yes on that.
Yeah. I think there was definitely an overwhelming yes to the fact that it should be treated as property because it creates all these rights. So so there we have it. That's the property, digital assets, etc. bill, which
etc.
should be. Coming an act, we hope, fairly soon. But meanwhile, I think the courts, they're still doing a good job on that front.
Well, that's it. I think that's a good point to make. Yeah, you don't have to wait till this bill is passed to take action. The courts are still there. They haven't disbanded.
No.
And they can help, of course. So yes.
Great. Well, thanks, Kieran. That was a good canter through.
Thank you, Roman. Yeah, good to see you.